एलएलएम को लागि तयारीको लागि नलेज अफ लबाट साभार गरेको छु। इन्ट्रोडक्सन्स टु ल भनेर। इन्ट्रोडक्सन टु ल, देयर इज नो युनिभर्सली एक्सेप्टेड सिंगल डेफिनेसन अफ ल. Definition of one jurist differs to another jurist. However, various jurists and scholars make their efforts to define law. Law is a social science, grows and develops with the growth and development of society. New developments in society create new problems, and law is required to deal with those problems. According dictionary definition of law, it means a rule established by authority or by custom. It regulates the behavior of a community, country, etc. In other words, it is the legislative pronouncement of the rules which should guide one's action in society. To say it is a rule of actions to which human beings conducted must conform. There are differentiations in defining of law due to their ideological approach to law. Definition of law is a rule of conduct developed by the government or society over a certain territory. Law follows certain practices and customs in order to deal with crime, business, social relationship, property, finance, etc. The law is controlled and enforced by the controlling authority. In another word, law signifies a rule applied indiscriminately to all action. It is a notional patterns of conduct to which actions do or ought to conform. Law is a large body of rules and regulations based mainly on general principle of justice, fair play, and convenience, and which have been worked out by governmental bodies to regulate human activities. In broader sense, law denotes the whole process by which organized society through government bodies and personnel, lawmakers, courts, tribunals, new tribunals, law enforcement agencies, and executive panel and corrective institution, etc. attempt to apply rules and regulations to establish and maintain peaceful and orderly relation among the people in the society. There have been conflicting and divergent views of jurists regarding the nature, concept, basis, and functions of law. Law has been regarded as a divinely ordained rule or a tradition of the old customs or recorded wisdom of the wise men or philosophically discovered system of principles which expresses the nature of things or as a body of ascertainment and declaration of an and immutable eternal or immutable moral code or as a body of agreement of men, women in politically organized society, or as a reflection of divine reasons, or as a body of commands of the sovereign, or as a body of rules discovered by human experience, or a body of rules discovered through juristic writings and judicial decisions, or as a body of rules imposed on men, women in society by the dominant class, or as a body of rules in terms of economic and social goals of the individuals. Therefore, law can be defined firstly by its basis in nature, reason, religion, or ethics. Secondly, by its sources like custom, precedent, and legislation. Thirdly, by its effect on the life of the society. Fourthly, by the method of its formal expressions or authoritative application. Fifthly, by the ends that it seeks to achieve. Although there is no general definition of law which includes all aspects of law, yet for a general understanding, some of the important definitions are as follows. Aristotle defined as it perfect law is inherent in the nature of man and women. It perfect law is inherent in the nature of man, women, and can be discovered through reason. It is immutable, universal, and capable of growth. Austin says law is the command of sovereign, rules laid down by political superiors to political inferiors. In other words, body of command by a sovereign member or member of an independent society wherein the author of law is supreme. Salmon defined law is body of principles recognized and applied by the state in the administration of justice. That is, principles recognized and applied by the state in the administration of justice. HLA Hart define law as law is the combination of primary rules of obligations and secondary rules of recognition. Primary rules of obligation and secondary rules of recognition. Pattern. Pattern defines law as law consists of a body of rules which are seen to operate as binding rules in the community, by means of which sufficient compliance with the rules may be secured to enable the set of rules to be seen as binding. Blackstone law is the most general and comprehensive sense means or rule of actions, whether animate or inanimate, rational or irrational. Thus we say the law of motion, gravitation, and nature and of nation. Kelsen defines law, norms of human behavior or pure theory of law, which provides that law is pyramid of norms which has its generis form on ground norms. For example, Constitution of Nepal. Avi defines law as, in the words of Avi, law is the reflection of public opinion. He defines law as the form of the guarantee of the conditions of life of society assured by state power of constraint. Savagny defines law as law is a matter of unconscious growth within the community and can only be understood in its historical perspective. Savagny's Boggist theory of law means will of the peoples. Roscoe Pound law is a social control through systematic application of force in a politically organized society, an instrument to satisfy the maximum wants in a society with the maximum of frictions and waste. Purpose of law. Purpose of law. Law is defined as a body of rules of conduct or action that has been prescribed by the controlling authority and has a legal binding force. Although force, also the law must be followed and obeyed by all the citizens. Failing to do so will result in legal consequences of the law. Law is an instrument which regulates human conduct, behavior. Law means justice, morality, reason, order, and righteousness from the viewpoint of the society. Law means statutes, acts, rules, regulations, orders, and ordinance from point of view of the legislature. Salmon retains the emphasis on the judicial process but considers that a reference to the purpose of the law is essential. The law may be defined as the body of principle recognized and applied by the state in the administration of justice. Justice is the end of law, and it is only fitting that an instrument should be defined by a delineation of the purpose. This raises the questions of the relationship of law and justice, in which one theory defines law in terms of justice, but from this it follows that the unjust law cannot exist for it. For if it could, then on the promises there would be a fatal cell contradiction. Many writers have fallen into a simple trap. Earlier theories of natural law put the emphasis on justice and denied the validity of law. If it was opposed to natural justice, but Salevi condemned by natural law, opposed to natural justice, but Salevi condemned by natural law, yet exist in the legal systems of the time, and through thought the Romans recognized this difficulty. They never succeed in solving it. A second means of solving the problem of the relationship of law and justice is to place all the emphasis on law and regard justice as near conformity to law. By then we are depriving ourselves of a criterion which may not be wholly subjective, by which we may test the operations of a legal system. The purpose of the law is essential to an understanding of its real nature, but the pursuit of justice is not the only purpose of the law of any period. So many ends and doors and will vary as the decades roll by, and to seek for one term which may be placed in a definition as the only purpose of law leads to dogmatism. Dogmatism, the end that seems most nearly universal is that of securing order, but this alone is not an adequate description. Indeed, Kelsen regards it as a pleonasm. Pleonasm, since the law itself is the orders of which we speak. Function of law. Function of law. The concept of the function of law is of major importance. It is needed to explain the nature of law, to explain disciplines associated with law, to correctly interpret and apply law, to pinpoint the interactions of law with social norms and institutions, to determine which general principles to which the law should conform or deviate, and to explain the law within the context of normative philosophy. This chapter aims to contribute to the elaboration of the comprehensive region scheme of the functions of the law. In it, the questions of the social functions of law are distinguished from the question of clarifying legal norms into distinct normative types. The four primary functions of law: preventing undesirable behavior and securing desirable behavior, which is performed in criminal law and torts; providing facilities for private arrangements between individuals, which is found in private law, criminal and tort law; provision of services and the redistributions of goods found in legal systems; and settling unregulated disputes found in courts and tribunals are discussed in the chapter. It also tackles the secondary and indirect functions of the law. The secondary function of the law include the determination of procedures for changing the law and the regulation of the operation of law applying organ. The chapter concludes with the discussion of HLA Hart classification of law. Thus, laws performed various functions. One of the most accurate function of law was started by Roscoe Pound, who treated law as a species of social engineering. Species of social engineering. Roscoe Pound stated that there are four major functions of law: one, maintenance of law and order in society; two, to maintain status quo in society; three, to ensure maximum freedom of individuals; four, to satisfy the basic need of the people. The most basic and common functions approved by jurists is to ensure well-being of the society by keeping order. The function of the law is in a society are much clearer than the function of law in a general sense, which would rather be termed as the purpose of law. One, maintenance of law and order in society; two, dispute settlement; three, social change; four, protection of fundamental rights; five, social control; six, control of political system; seven, the regulations of economic activity; eight, international relations; nine, regulation of human relations. The main function of law in a society are discussed in detail below. Maintenance of law and order in society. Law are directives that govern and regulate human behavior and conduct of code of conduct to ensure order. They are made for people within a territory to abide with. Laws are also responsible for keeping peace of a society country intact. Keeping peace of a country intact. Many countries possess a very diverse population. If the same law is applied throughout the population, irrespective of their diversity, different needs and differences in opinion, it would cause conflict. Hence, laws are drafted to cater the needs of different parts of the society and help in maintaining peace in the society, peace in the country. For example, in a secular country like India, the constitution leaves certain subjects like marriage under people respective reason. These laws are called personal law. Dispute settlement. Disputes are unavoidable in the life of society, and it is the role of the law to settle disputes. Thus, disagreements that are justiciable. Thus, disagreements that are justiciable will be resolved by law in court or out of court using alternative dispute settlement mechanism. Social change. A number of scholars agree that the role of law is modern society as instrument to social change. Law enable us to have purposive purposive law enable us to have purposive, planned and directed social change. Of law provides some measures of discretions in law to make it adaptable to social condition. If law is rigid and unalterable, it may not respond to changes spontaneously, which may lead to resentment and dissatisfactions among the subjective subjects and may even result into violence or revolution. Therefore, some amount of flexibility is inevitable in law. Protection of fundamental right. There would be no use of any law that does not work towards protecting and securing the right of people. Law is in place to maintain order and benefit the society. They are written to cater to people's needs and interest. In cases of crimes, laws punish violators in order to ensure that the basic rights of the people are protected and further set example to ensure security. Thus, one of the most fundamental functions of law is to promote and protect human rights. Social control. Member of the society may have different social values, various behaviors and interests. It is important to control those behaviors and to inculcate NCULCAT socially acceptable social norms among the member of the society. There are informal and formal social control. Law is one of the forms of formal social control. Roscoe Pound law is a highly specialized as to Roscoe Pound law is a highly specialized form of social control in developed politically organized society. Control of political system. Law and politics have an obvious relationship. One of the major governmental functions is to draft and amend law in the interest of the people. However, the political system is also subject to law and has to perform its duties according to law and be responsible for its consequences. Law also govern and control the political system by predetermining the duties, the structure of the system, and who qualified to be a part of it. The regulations of economic activity. Law also sets rules and regulations that must be followed while performing economic activities such as sale, trade, labor, and investment. Law is needed to have valid and legal business deal and agreement. Laws such as sales tax, income tax, goods and services, TAS, GST, and customs law are also responsible for government revenue that are used as funds for investing in the development of the country. Hence, law is also responsible for governing the economic sector and its counterparts to ensure ordinance. Regulation of human relations. Human relations such as contracts, agreement, families, and marriages also come under the purview of law. Laws plays the function of keeping human behavior and relation in a check. This thus it automatically influence human relations by restricting unacceptable behavior. For example, adultery. It is also responsible for clarifying the correct procedures of entering legal relationship, its legality and validity. Cases in marriage like divorces are needed to be approved by the law and registers in order to be valid. Hence, law holds control over the regulation of human relation. International relation. Law is responsible for conducting and making international relation. It plays an important role in forming economic, diplomatic, and strategic relation with other nations. Visa law is also responsible for allowing people from other countries to enjoy the services provided by that nation. Laws are also used against policies and demand of other nations and protect and promote the nation's interest. Thank you. God bless you all. हजुरको एक्जाम सफल रहोस्. एलएलएममा हजुरको इन्ट्री होस्. मेरो च्यानल सब्सक्राइब गरिदिनु.